Welcome back. Good to have you here. And what I want to do is this time is carry on a little more with the role that psychiatrists have been playing in the courtroom to illustrate a little bit more about why we don't need them. Not that the issues that they're asked to help us with will disappear, but that we can do a better job if they were not getting in the way. And I'm speaking now of this question of competency for trial. So let me explain a little bit that the issues in competency for trial have to do with the current state of mind of the accused. We've been talking in the past about it, like an insanity or diminished capacity. That has to do with a defense that relates to your state of mind when you committed a crime sometime in the past. We've also spent some time talking about danger and whether psychiatrists can help us with future behavior. Danger implies something you might do in the future. And you know by now, of course, that I don't think psychiatrists can help us with either one of those, past state of mind, future danger. But then we have present. Competency for trial deals with the question of, at the time that the trial is going to happen, are you able to understand the charges against you, or are you so out of touch with reality or mentally disordered that you don't understand the charges against you? Or even if you are able to understand the charges against you, are you able to rationally assist your attorney? And if you're not able to do either one of those things at the present time of the trial, then you could be found by a judge, usually a judge, but I guess it could be a jury trial, but normally it's a judge. You could be found incompetent to stand trial and given the benefit, I put it in quotes because I don't accept the, but you'll hear about that in a minute. You will receive treatment in a hospital to help you regain your competence. So it's supposed to be something we grant you as a grace so that you don't have to go to trial and face the possibility of being found guilty and being punished if you're not in a condition to get a fair trial. Now, I can't say that it's never worked out that way, but I can say, based on my own experience studying such cases and testifying about the inability of psychiatrists to help us determine whether somebody's competent, that it doesn't work out that way in case after case. It ends up being a way in which tremendous injustice can be perpetrated, either on the accused, where they end up being locked up and have things done to them that can be very dangerous and against their will, without ever having been found guilty of anything, or it can be unfair to society, because a person can end up being released and more or less not being held accountable for what they did. And either one of those is wrong, and psychiatry contributes to that. So let me give you one example where it's the individual who is the victim of injustice. This was a gentleman who had been accused of an assault. Now, I was not party to the trial of whether, or the facts of whether he the facts were good in that case. So we have to leave it there. He was accused of it. He was innocent until proven guilty. He never had a trial because his attorney decided to enter a plea that his client was incompetent to stand trial. Now that can be done without the consent of the person. And it was decided that he was incompetent to stand trial. He was then put in a mental hospital. He didn't want to be in that mental hospital. He didn't want to get the treatments that they insisted he get, which was mainly medications. And because he would not accept these treatments, or was only reluctant to do it and wouldn't talk in these various therapy modalities, they were not willing to release him year after year after year. He was called a schizophrenic. And I can tell you from my own experience that that label really tells you nothing, because If you don't get a very serious diagnosis attached to your record, then it'll look kind of unusual that a person will be held there year after year if he's not a schizophrenic. So it's a self-justifying kind of label which protects the hospital and the psychiatrists. And that's what this man had been labeled, as a schizophrenic. Year after year, he'd been continued to be labeled as schizophrenic because he was not participating in therapy. That was the basic issue of it. He was not participating. Eventually, I got a communication from him and his lawyer asking me if I would be willing to look into the case. I agreed to do that, and when I went and interviewed him, I found nothing irrational about the man. I found that he could tell me about the facts of his original case. He told me about his treatment and how he did not want to be there. He wanted to go to trial. He wanted to see whether he would be found guilty or not guilty and accept his punishment. That's what happened. The psychiatrist wouldn't agree until finally I wrote a report, and eventually that report, I think, and other factors led to an arrangement being made in which the court agreed that he would not be continued to be held in the hospital. He would be put on a conservatorship instead of being incompetent to stand trial. So in other words, for practical purposes, after serving 10 years in confinement, it was a hospital, but it's a prison. Basically, if you're in a building that you can't leave, it's another form of a prison. So after 10 years for something he'd never been convicted of, he was finally released on a conservatorship, meaning he would have to stay on medications for the rest of his life, in all likelihood. Of course, I didn't follow him for the rest of his life, but in my judgment, it's very likely that he would be kept on those medications under the threat that if he refused to take them, he would be put back in the mental hospital again. In his case, what you end up with is a life sentence of either out-and-out confinement in a building somewhere or chemical confinement with medication, drugs, that he didn't want to take. And I submit to you that that is a corruption of the original intention of the law to supposedly do this person a service by giving him an opportunity to become competent to go to trial. It becomes a perversion of initially what I'm assuming is a good intention, to be fair to people. But it's the presence of psychiatry which makes it so easy for it to turn into either a life sentence or a long confinement, because it becomes medicalized. In essence, his refusal to participate in treatment was labeled as a disorder. So there you have injustice to the person accused. Now let's talk about injustice to society. Because after all, a prosecutor in a criminal trial represents the people. It doesn't always work out that way, as I'm pretty sure you probably know. But that's the theory. The people versus John Smith. So that was a case in Hawaii where a young man had been apprehended, and the evidence was very strong. There really wasn't any doubt about it after I studied the case. Nobody was contending that he was the one who was tricking young girls through various ruses of being injured into helping him. And when they tried to help him, he was then assaulting them and raping them. And he was eventually caught, and he was examined by psychiatrists hired by the defense, who ultimately concluded that this man had a multiple personality. And it really wasn't the man on trial who had done it, but it was his other personality. Let me just tell you now, although we can perhaps get into another whole session, that there is no such thing as multiple personalities. It doesn't exist. It was an invention that came from psychiatry and lasted a long time, and it's still, in many people's minds, they believe it happens because they've seen it in the movies or read about it, or trials in which it was entered as a defense. But it's an invention. But this man was successful in being found not guilty by reason of insanity because the court accepted the idea that it was the other personality that had done it, but now that other personality had been pushed back into the background, was no danger the other personality was going to come out, and so he was not guilty. Now, I submit to you that that is an injustice to society because we allowed people to be qualified as expert witnesses to make claims that have absolutely no scientific basis and corrupt the thinking of either a judge or a jury, whichever was deciding the case. So let me finish by just illustrating why it's so clear that we don't need them in trials of competency to stand trial. I'm not arguing that we shouldn't have a provision for a person to regain their ability to stand trial. I think it's vastly overused, but never are psychiatrists able to help. They have no tests or examinations which are nearly as good as simply the evidence of their behavior around the time that the trial is taking place. There are people who are observing the person. They will have been arrested, or there wouldn't be a trial. Observers of the person's behavior, even the impressions of a judge in court. All this will allow you to decide, the court to decide, does the person understand the charges? Is the person's behavior such that they can be worked with? It's an invention that allows psychiatry to corrupt the process. So it would be really quite easy to simply get them out of it, and there would be few findings of incompetency for trial. There are some situations where prosecutors have abused the system, and they're the ones who enter the plea that the person's incompetent because they get the person locked up even though they haven't proved any guilt. It's time to stop it. We don't need it. It's just the corruption of the system. Thanks a lot for coming. We'll see you next time.